give you a notice, we can decide the matter ourselves. So please proceed in your own way.
While concluding,
दो चीजें देख लेते हैं जी. ये तो यहाँ तक everyone agrees that there were certain issues regarding 184 which agitated or which disturbed the executive, the parliament. Fine. Point taken. Second point, the law that you enacted, that law, everyone agrees कि ठीक है, law में कोई ऐसी चीज नहीं है, बाज यहाँ होगी, लेकिन वो law, no one said कि ये law जो है ये किसी तरीके से infringe कर रहा है आपके fundamental rights को as such, directly. असली जो मेन चीज आपने एड्रेस करनी है वो है लॉ की, आपकी जो लीगल कॉम्पिटेंस है, उस लेजिस्लेटिव कॉम्पिटेंस. आप प्लीज उस पे आ जाए.
My lord, I'll come to the question that you had raised before.
आप अपने आर्ग्यूमेंट्स करें. My question, take it at the end. पहले अपने आर्ग्यूमेंट्स खत्म करें, like the चीफ जस्टिस just said कि भाई पहले उनको तो बोलने दे. आप जो आप बोलना चाहते हैं प्लीज बोल.
बल्कि सारे क्वेश्चन का जवाब आप बाद में दे दें, पहले अपने
आर्ग्यूमेंट्स. My lord, as far as provisions other than section 5 are concerned, with regards to practice and procedure, I have submitted that the competence is drawn from article 191 read with entry 58 and of course together read with 142A. 191 in itself acknowledges, recognizes Parliament's power to make laws with respect to practice and procedure, and the term law used in 191 does not in any manner exclude an act of Parliament.
ये जो आप अगर एंट्री 58 को देखें, इसमें एंट्री 58 में आप किस उसमें आ रहे हैं? विद इन द लेजिस्लेटिव कॉम्पिटेंस ऑफ मजलिस शूरा,
yes,
or relates to the federation?
First part.
Okay, and so your reliance on item 58 is directly dependent upon or flowing from your arguments that 191 confers legislative competence.
Yes.
Okay, point taken.
So this is the conclusion or some of what I have submitted on as far as these are concerned. Okay. Now, and then comes section 5, which is a substantive right of which has been conferred, and which obviously, at least in my my submission is that for that we have to go to entry 55, and entry 55, my lord, does two things. It empowers the Parliament to legislate with respect to jurisdiction and powers of all courts in all, with respect to all the matters in the list, and to such extent as is expressly provided by or under the Constitution. And as far as Supreme Court is concerned, it empowers the Parliament to only enlarge its jurisdiction and confer supplemental powers on it. So it does deal with Supreme Court's jurisdiction and powers, but only to enhance them, not to curtail them. But as far as other courts are concerned, both things can happen, subject to what is provided by or under the Constitution, the language of the Constitution.
So once that jurisdiction has been enlarged, that act cannot be repealed.
My lord, I was thinking about the question
cannot
that
be
you
taken away.
You mean to say that enlargement of jurisdiction includes right of appeal?
Yes, yes, sir. Because this is the appellate jurisdiction of the Supreme Court, which exists in the Constitution, the appellate jurisdiction. It is that jurisdiction.
In fact, the original jurisdiction has been enhanced. Under Article 184(3) is the original jurisdiction.
Original jurisdiction.
It has been enhanced by enlargement.
So my submission and my response to your question, my lord, is that nothing in Articles 184 or 185 provide any extent to which they can be enlarged, because they do not so there is no bar on the Parliament to the extent to which the jurisdiction can be enlarged.
Is there any limit of enlargement, because the right of appeal has been given with retrospective effect? There is no cut-off date and it is open-ended. This question was also asked by me to Mr.
Yes.
Salahuddin,
Yes.
where it was not responded.
Mr. Attorney General, you have not given the details of express authorization. That requires your...
My lords may note Article 212(1), subclauses A, B, C, and then read with clause 2 of Article 212 with respect to administrative courts. It does both things. It provides to the extent to which those courts will function, the powers those courts will exercise, and then in clause 2, it then places limits as well, that no other court shall then exercise such powers. Thus, what this clause 2 does is places limits on the Parliament's power. The extent of authorization with respect to administrative courts is thus then covered under clause 1, A, B, C, and then
only
clause 2.
related to the administrative tribunals and courts. How this
So
is
this is all courts, sir?
helpful to you with regard to section 5, which has been introduced into the new act.
वो अब इस पे मैं इसको जरा conclude कर दूं इस बात को आगे. As far as article अब territorial jurisdiction, for example, of the High Court, वो extend हो
Section
सकती है.
5 is substitute of 185.
कि मैं उस पे आ रहा हूँ. मैं
उसको
भी
बताएं ना
वो
आप.
वाला पार्ट एक्सप्लेन कर रहा हूँ जो सवाल था आपका कि कहाँ वो बताई हुई है बाय और एक्सटेंड.
नहीं वो एडमिनिस्ट्रेटिव कोर्ट्स की बात
नहीं, मैं अभी जरा
वी आर टॉकिंग अबाउट द सुप्रीम कोर्ट
जी मैं उसी पे ही वापस आऊंगा ना जब मैं ये कंप्लीट करूंगा.
विद रेफरेंस टू अपील.
जी दूसरी जो एग्जांपल है, दूसरा इंस्टेंस, नॉट एग्जांपल, दूसरा जो इंस्टेंस है 192
सवाल और भी ले लीजिए. जब आप 184(3) की अपील देख रहे हैं और लेजिस्लेचर ने या पार्लियामेंट ने महसूस किया कि यहाँ पे एक राइट ऑफ अपील होना चाहिए, तो फिर 184(1) की क्यों नहीं अपील दी गई? उसके बारे में क्यों नहीं सोचा गया? Why only 184(3)?
I'll address this. आप आर्टिकल 192 क्लॉज 5 देखेंगे.
Mr. Attorney General, to add to that, if your argument was taken on its face value that enlargement is unrestricted and there is no limit given, then do you think by a legislative instrument 2 other appeals can be provided under 185? Let's say उनका जी एक अपील जो है वो 3 मेंबर बेंच ने डिसमिस कर दी है, उसके अगेंस्ट एक और अपील होगी जो 5 मेंबर बेंच सुनेगा, और वो अगर डिसमिस होगी है तो एक और अपील होगी जो 7 मेंबर बेंच सुनेगा. By definition, if there is no limit, then you're just enhancing, and you're enhancing through a legislative instrument which finds no support from the Constitution.
Noted, my lord. I'll come back to this question. My lord, back to clause 5 of article 192, which permits through an act of parliament extension of High Court's jurisdiction to areas beyond the provinces, which are not part of the province. So that is also...
You have already argued this point.
Ji. So this is also an instance where authorization is provided. Now, as far as enlargement is concerned, now if I may, my lord, you have a question?
I'm just waiting for the answer of retrospectivity.
Ji. Oh, there are so many questions and there is
I
so
understand.
उसमें problem ये होता है,
There is
my
a
lord, कि
problem.
उसमें फिर कोई एक question miss हो जाता है, and that is sort of unfair to the lordship and leadership who have asked that question.
एक मिसाल मैं देता हूँ जी साहब. बलूचिस्तान में पहले प्रोविंशियली एडमिनिस्ट्रेटेड ट्राइबल एरिया होते थे, जो अभी अमेंडमेंट के तहत खत्म हो गई, तो हाई कोर्ट की जुरिस्डिक्शन वहां तक स्पेशली एक्सटेंड की गई थी. इनिशियली देयर वाज कोर्ट हैड नो जुरिस्डिक्शन, देन सब्सिक्वेंटली इट वाज एनहांस्ड.
उस पे तो कोई बार नहीं है.
तो वो एक्सटेंशन उस सूरत में होती है हाई कोर्ट. जी जो आप कहते हैं हाई कोर्ट की जुरिस्डिक्शन टू द एरियाज व्हिच डज नॉट फॉल विद इन द प्रोविंस, उन एरिया तक वो जुरिस्डिक्शन रहती है.
Yeah. So this is an authorization under the Constitution to an act of Parliament.
Attorney General,
My lord,
ये पहले retrospectivity की जरा जवाब दे दें.
retrospectivity to enlargement.
Yes, please continue.
Have I addressed your question? I have not.
I'm in no rush. Take your time. Take your time.
My lord, as
Mr.
far
Attorney General, answering a question and us finding your answer appropriate are two satisfactory are two different things.
Two different things.
So we may not agree with you.
Yes. I'm just hoping that I can persuade the majority. That's the
Should hope to everyone.
No, I want to persuade everyone, but because we are in full court.
That's a very lawyer's remark. Majority.
But after arguing for all of us put together. No, I understand.
As Attorney General, you should say I should be able to convince the whole.
No, because on full court, I have to go back to leadership, so it is part of that. Retrospectivity. Now, my lord, I see the the concern that my lords have on applying this law retrospectively and thus opening sort of doors to perhaps a lot of litigation. My lords, there are several cases, many cases which are no longer live issues.
Before you even address this question, does this law state explicitly whether its application is prospective or retrospective? Does it state so?
Subsection 2 of Section 5, my lords.
Yes.
जी पढ़िए.
Says the right of appeal under subsection 1 shall also be available to an aggrieved person against whom an order has been made under clause 3 of Article 184 of the Constitution prior to the commencement of this act.
Prior to the commencement. So its application is retrospective.
Yeah. So,
and it excludes any order passed under Article 188, where a review has been decided.
Does it attend to what my lord is observing?
my lord,
No, does it, first of all, before your opinion, does the statute say anything or it's silent on it?
it is silent on what happens if or what happens to the cases against which reviews were
No,
filed and
if it
decided.
is silent, it may not be appropriate for us to comment upon it. Or should we comment upon it?
My lord, if in my submission, because this might affect the people or the appellants if this law is upheld and declared intra vires, who may come before you relying upon this provision, and at that stage you will have to decide the maintainability of that appeal on the basis, which is to say whether a remedy of review if it has already been exercised and not
After hearing that party,
yes,
who is not before us.
who's not. So that is why, my lord, if you permit me, that I do not make any submission as far as the proceedings which may have culminated into review and having been decided. So that is.
And
this
what
is
about the
something which-
effect of the law?
What about
When it will be effective, from the date of its promulgation or with retrospective effect?
Now, my lord, the language of subsection 2 is broad. It says prior to the commencement of this act, which then means, what it means is that, it go back in time and apply. Now, there has been at least one example and several others as well, but the National Accountability Ordinance, for example, Parliament chose to apply it from 1985, and in Asfan Jarwali, my lords found it to be constitutional. So my submission is that, and this is something that I'm not stating on the basis of any data before me. I mean, I have no way to find out whether the case is decided under 184.
Do you remember any law? Do you remember any law in which the right of appeal was given with retrospective effect in our country?
Top of my head, I can't. I think.
I think that isn't it the principle, I may be wrong, correct me if I'm wrong, if it's a beneficial piece of legislation, its effect may be retrospective, but if it casts onerous obligations on the subject, then it is always construed prospectively. तो ये principle है.
Principle है जो retrospective application से laws की, otherwise if it is to the detriment of any party, ये principle applies.
So that is the branch of curative legislation.
So
You see,
when my
when
lords,
it happens in curative legislation.
yes.
If the legislation is curative, but it is new law. You see,
My lord,
we have not made
I think-
any amendment in the previous law. This is new law.
I think it's again, I think it will turn on something which if it has become a past and closed transaction in the sense that it is no longer a live matter, my lords may
Mr. Attorney
decide it in
General,
a
I
due
am
course
again
of
not very
proceedings.
happy with this phrase or concept or idiom or legal concept of past and closed transactions. This is something also which has been determined, evolved by this court, or it is a jurisprudential principle of well-established jurisprudential principle of past and closed transactions?
My lords,
Can I add a small question?
Yes, of course.
Where a right of review has been exercised, does it takes away the right of appeal if the same is provided by the statute?
Your Ladyship, a very important question. I think if I may, it does not. I mean, the grounds are completely different. Review is very narrow.
Or even if I think that's a valid question. एक जरा से इसको मैं rephrase कर दूं. An order has been passed. A person thinks, he simultaneously files both review and an appeal. Just to err on the side of caution, he thinks that, or she thinks that order can be reviewed because some error on the face of the record. But being very cautious, also simultaneously files an appeal. So if the review is not maintainable, it doesn't mean the appeal goes away or vice versa, which it's an interesting thought which Ladyship has put forward. I just hope developing the thought.
Doctrine of election will perhaps apply in that case. I mean, if it is exercised when both remedies are
Doctrine
available.
of election is available when two remedies are before you. Doctrine of election when
both remedies
are available.
That's what I said.
But in this case, if the subsection 2 is sustained, then the persons who have already attempted for review and their reviews have been dismissed, they may also come and say that the right of appeal is a greater right than the review. So we are also entitled to file the review because this has been given with the retrospective effect.
They may, sir.
Yes.
They may.
And they will be right
They may, sir.
if they do so.
Yeah.
No, in my personal opinion.
That is what I think my Lord would be dealing with when those matters or when any such matter comes before your Lordship.
Speaking for myself, I think the language used by the legislature is very clear, and it does not relate to an order passed under Article 188. So it's only when an order
My Lord,
has
to
been
that
passed.
extent, if I may submit, my Lords may give this finding if this law survives and if any matter comes before your Lordship, my Lords may give a finding and there would be a question of maintainability of that.
For instance, I'll give you a hard example of an actual case, which I believe there is some challenge to it. There is the famous case of the Prime Minister of Pakistan, Zulfikar Ali Bhutto case, where the matter was, a decision came by the Supreme Court where minority acquitted, majority maintained the conviction. Then came the review in which the minority joined hands with the majority and dismissed the review because the scope of the review was very extremely narrow. Surely we are not faulting the judgment of the minority who joined hands with the majority. However, if this law existed then surely that would say that our limited jurisdiction has now been expanded to an intra-court appeal jurisdiction, and now we can do so. So this is an actual case where the review usually doesn't happen, that the minority joins hands with the majority in dismissing the because its scope is limited, and this case is an actual case, and suppose this intra-court appeal right then existed, then surely the fact that the review was dismissed would not have, in my opinion, closed the doors to an appeal. How would you like to comment on that?
My Lord, I bow before your Lordship, but as I said, I think this is something which can be addressed in due course if a matter comes before
Mr. Attorney General, that was entirely on different premises because the original jurisdiction was exercised by the High Court, then appeal was before this court, and subsequently there was review.
I completely agree with my learned brother, but I'm saying suppose you can still say that review not maintainable because, I'm just giving you an example, of course that was not a 184 case, but I'm saying there could be a case where I say, sorry, no case for review made out, but it may be a case for appeal still. I don't know.
Review आपकी dismiss हो जाती है for non-prosecution.
Election का
अभी फिर अभी वो उसका देखिए, I think we should not touch this.
नहीं, और उसमें ये होगा कि
I think we should leave this aside. We should leave this aside because actual cases may come up before us if we sustain the law.
In future, if the law is intra vires, and of course, both remedies will be available, an appeal under Section 5 and a review under Article 188. Whatever the litigant elects first becomes his remedy and is precluded from exercising the other.
Okay, so we are in Section 5.
Yeah.
Now I have a question. Section 5 and this entire law relates to practice and procedure. So,
Section 5, sir?
no, the entire law.
Yes, the rest.
Section 5, we are conferring jurisdiction, appellate jurisdiction, which is by all intents and purposes and by all definitions a substantive.
That's right.
How do you bring it within the purview of procedural law to provide a substantive right?
My lord, a law may provide for, a law may provide for both the procedure and may contain some substantive provisions. What my lords had just observed, what has to be seen is whether there is legislative competence that exists for both. So my respectful submission, my lord, is that there is legislative competence for sections 1 through 4 and 6, 7 and 8 under 191, and then there is legislative competence under 55 for section 5. So both on that plane, the law we do not, the law can survive so long as there is independent legislative competence for both substantive provision and procedure.
At this stage, Letter Attorney General, how you respond to the objection of the petitioner that constitutional amendment was required for section 5?
My lord, as I just submitted that the entry 55, my lord, permits the Parliament with respect to Supreme Court to do two things, which is enlargement of its jurisdiction and conferring of supplemental powers. So the language which says except the Supreme Court, what it does is it requires the Parliament to limit its legislation only to this extent, which is to say that Parliament cannot reduce the powers which the Constitution confers upon the Supreme Court, because the Supreme Court's powers are all provided in the Constitution. Unlike High Courts, for example, where the original jurisdiction flows from the Constitution, but the appellate, review, revisional jurisdiction or original jurisdiction on civil side under various statutes flows from entry 55, Article 142A with entry 55.
Mr. Attorney General, just a question on
it does not change the language or structure of 184.
My lord, in completing my submission on enlargement, because there is authorization, there is permission to enlarge jurisdiction, and there is no restriction in 184 or 185, by extending 185 to judgments and orders which are rendered under 184.3, therefore, a legislation on the basis of entry 55 enlarging the jurisdiction of this, appellate jurisdiction of this court and applying to judgments and orders under 184.3 is permissible.
So, coming back to my question, going by your thesis, then what is to prevent the Parliament from providing a second and third appeal in 185 through legislative, ordinary legislation? That we are extending the jurisdiction of the court by extending second, third, fourth appeals.
May short answer maybe with respect. When that happens, we look at it.
I think let the attorney.
No, yes, but I'm just saying.
My lord, my submission to that would be that, for now, this is the first appeal which is being provided under 184.3.
No, आप principle settle कर रहे हैं ना कि आप extend कर सकते हैं एक constitutional appeal by ordinary legislation. So, I mean, by that token, if the Parliament tomorrow wants to provide second, third, fourth appeal, can it or can it not?
My lord, if I may.
मैं सिर्फ उस
मैं अपने thoughts को जरा अपनी submissions को
does it have legislative competence to do that or not?
ये जी साहब अगर आप 185(2) पढ़ लें तो शायद आपको जवाब मिले. 185(2) कॉन्स्टिट्यूशन से एन अपील, मीनिंग एन का क्या मतलब?
नहीं होगा नेक्स्ट टाइम.
क्या दूसरी अपील
The question is different. The question is
if I just give my submission in form of a question, that if through a constitutional amendment,
I'm not talking of constitutional amendment.
I'm just if through a constitutional amendment, if the Parliament had provided under 184.3 that there would be a first appeal and then narrowing the scope of the and a second appeal, narrowing the scope of that second appeal as it is provided in its. Let's say if it was done
Counsel,
so.
I take your point. My question is very, very simple. One, you say, in terms of item 55, you can enlarge the jurisdiction of the Supreme Court and there is no restriction on how far, how much, and since when. So by that token, it has untrammeled, unrestricted powers to enhance and enlarge jurisdiction of the court. So tomorrow, if the Parliament wants to provide a second and third appeal on your premise that there is no restriction, they can do that by saying we are enhancing the jurisdiction of the Supreme Court. Now onwards, in 185, there will be a second appeal, a third appeal, a fourth appeal. Can they jurisprudentially, are they competent to do that? And if they are, then say yes.
My Lord,
So if I could just jump into this discussion, I think it's a very pertinent question and perhaps it might be subject to judicial review later on. But just a related question would be that when we read this, because this thing is slightly important to understand, this to such extent as expressly authorized, one reading of it shows that the word expressly was also underlined earlier. What does it mean? So to such extent is expressly authorized. So it means that there could be a possibility that it is not authorized. I mean, there is no extent given. Extent to such extent means that there might be an extent, but there might be no extent. So there could be situations where there is no extent, no express authorization is given, and the field is open.
Yes.
What do you say to that? I mean, it's not as if every provision, every jurisdiction will give an extent. As long as there is an extent, then Parliament is going to be regulated by that. But if there is no such extent expressly authorized, what do we do? I mean, then it's an.
if my Lords
Constitution has not provided that extent.
My Lords may
so
kindly
Constitution then allows the Parliament.
My Lords may kindly to Article 203 DD, Clause 3. This will answer my Lord's question. 203 DD, Clause 3.
Yes.
Now this says the court shall have such other jurisdiction as may be conferred on it by or under any law. So this then leaves it open to go as far, which the Federal Sharia Court can perhaps do. And then when you look at Article 199, Clause 1, it does not provide any extent to, there is no authorization to what could be done with the jurisdiction. But
if you say, what you're saying is, now you're contradicting the whole premise of your case. अगर फेडरल शरीयत कोर्ट में ये प्रोविजन दी गई है तो यही चीज तो सुप्रीम कोर्ट के साथ भी होनी चाहिए थी. अगर हम आपकी बात माने तो फिर तो दिस प्रोविजन जो आपने अभी
ये एक्सटेंट ऑफ ऑथराइजेशन है ऑफ ऑल कोर्ट्स. सो फेडरल शरिया कोर्ट इज ऑल कोर्ट्स. तो सुप्रीम कोर्ट की हद तक तो वो अप्लाई नहीं करेगा.
नहीं, हम जो चीज आप देखें ना, ये कॉन्स्टिट्यूशन ने क्लियरली स्पेसिफाई कर दिया. तो अगर आपकी हम बात माने तो यही चीज सुप्रीम कोर्ट के साथ भी उन्हें स्पेसिफाई कर लेना चाहिए था कि आप जुरिस्डिक्शन को कर सकते हैं ना.
माय लॉर्ड, ये इसका
नया जुरिस्डिक्शन.
बिकॉज विद रिस्पेक्ट अदर कोर्ट्स, respect to all other courts, and my lords will bear in mind that this Federal Sharia Court was an insertion later in time through 8th Amendment. But with respect to all other courts, the Parliament's power to legislate with respect to their jurisdiction and powers is broad. But with respect to Supreme Court, and this is the question that you had, that it begins by saying except the Supreme Court and then goes on. And what I submit is enlargement of jurisdiction and conferment of supplemental powers. With respect to Supreme Court, Parliament can only enlarge.
That point is taken that we read this extent with the upper portion, but suppose if we were to even read it with the other, what the reading of it shows that to such extent, the extent must be provided expressly. Suppose it's not provided, then what do we do?
Right. So if there is, if
184 doesn't give any extent of its jurisdiction.
My lord, then because it says to such extent as is expressly authorized by or under, then what it does is that only, I mean, one reading of it is, and this is what my Lord Justice Ijaz has held.
If I may follow up on that question, there is perhaps another way to look at it. Suppose the word expressly were not there. Suppose it said to the extent authorized by or under the Constitution. Then the possibility could arise that this could mean either express authorization or by necessary implication. Perhaps the insertion of the word expressly is targeting the possibility of removing, of there being no possibility of any authorization by way of implication, howsoever necessary it may be. Expressly means expressly, full stop.
And if
all implications are cut out on by use of this word.
Right.
Had this word not been used, then we would be back in our traditional approach, expressly or by necessary implication.
And for example, just giving an example, clause 5 of Article 199. Now, this is the power of the High Court, where the High Court can issue writs, and the definition of person then excludes certain persons. The Supreme Court, no writ can be issued to the Supreme Court.
No, but
and
that's an exclusion.
Yes.
मैं तो बात कर रहा हूँ ना कि expressly अगर ना हो तो आप उसके अंदर someone could argue कि भाई जो normal तरीका होता है कि और courts के कई judgments भी होते हैं expressly or by necessary implication, तो वो principle शायद apply हो सकता है. बट जब expressly कह दिया तो implication खत्म होती है. आपने express words दिखाने है या नहीं है, no matter how necessary it may be.
That's right.
Implication is out. Maybe
that's
that's
right.
one reason.
That's right. And that's why
what is your take on it?
जी मेरी take उस पे ये है कि
I'm
that
not
is
saying
why
it as I'm asking you a question.
जी
What's your
इसलिए
take on
I
it?
go back to what I was submitting with regards to entry 55, that the language list and to such extent as is expressly authorized